Good day to everyone and a very warm welcome to this webinar on the important topic of collective bargaining in 2021. My name is Vanessa Buerta. I am the training manager for conflict dynamics, and it really is my pleasure to be hosting and facilitating today's session. So, why this topic at this time? Well, many would probably agree that given our current backdrop of very low economic growth, extremely high inequality, poverty, and unemployment, and of course in the context of the COVID-19 pandemic, we can expect that collective bargaining in 2021 will probably be very tough. As we move further into this challenging year, many employer and labour parties are anticipating the commencement of the next round of collective bargaining, or perhaps you're already at the bargaining table. There's therefore an enormous need, we feel at this time, for developing a realistic understanding of the current bargaining landscape within our country, as well as seeking sober and sage advice for the best way forward, both in the immediate short term, but also, and perhaps even more importantly, in the longer term over the years to come. So in order to develop a deeper understanding of the status quo and to discuss proactive approaches to or for achieving outcomes of mutual gain for all parties involved in labour negotiations, we at Conflict Dynamics have invited three highly experienced and esteemed speakers to share their thoughts and viewpoints on this critical subject matter. But before I introduce you to our speakers, I would just like to give a brief overview of the process that we'll be following for today's session. The first part of the webinar will provide an opportunity for brief input by our three guests. They'll each be speaking for approximately 10 minutes or so to provide their perspective on the topic, and whereafter I will then pose some key questions to each of the speakers to gather a little bit more in terms of their thoughts on the matter. There will then, of course, also be an opportunity for you as delegates to ask your questions of the speakers, and this will take place via a Q&A session that, of course, being a webinar, will take place via the chat function. So please bear in mind that you are very welcome to submit your questions at any point during the webinar using the chat button, which you will find at the bottom of your screen. And I, together with my colleagues, will be collating the questions received, and we will endeavour to put as many of these questions as possible to our guests in the time that is available to us before we end at 12:30 today. We're very excited to be sharing this event with a very large audience today. And so as is per normal with a webinar of this kind, in order to prevent disruption and background noise, all of you as participants will remain muted. But again, that is why I stress, please do feel free to interact with us via the chat function with your questions and comments. Just a note that we will be recording this webinar, and we will make the recording available to you, to everyone who has registered for it, along with the accompanying slides after the conclusion, and you'll receive an email from us with those relevant details. So now, without any further ado, let me introduce to you our first speaker for the day. And we're going to kick off this morning with hearing from Mr. Mthimkulu Mashiya. Now, Mthimkulu is the General Secretary of the Transnet Bargaining Council, and this is a position which he has occupied since June 2009. He was previously a civil servant holding various positions within the Department of Justice during the 1980s, and he later cut his teeth in the trade union movement, where he held the position of Education Secretary of SASAWU, the South African State and Allied Workers Union, and he served in COSATU's National Education Committee, known as NEDCOM. In 2003, he was elected as COSATU's General Secretary and became a member of COSATU's Central Executive Committee, and then was subsequently re-elected in 2006. He then left COSATU in 2009 and moved into the position which he currently occupies as General Secretary for the Transnet Bargaining Council. Lastly, Mthimkulu, we're very proud to say, is a conflict dynamics accredited mediator and is openly passionate about the area of alternative dispute resolution. So Mthimkulu, could I invite you to unmute, and we look forward to hearing from you. Thank you.
Thank you very much, Vanessa. Thank you for that introduction. Yes, the collective bargaining season is indeed upon us. In fact, only yesterday I broke off after 7 in the evening from our own wage negotiations within Transnet. But just to come into today's topic, the state of collective bargaining, really, a lot can be said of our state of collective bargaining. Where I want to pitch my presentation is just to step back to where we come from. And as you can see there on the slide, we had this legacy of militant trade unions. I mean, we all know back in the day, trade unions were essentially very political organizations, fighting not just for workplace battles, but waging a battle for political change. I mean, recognized organizations were banned at that stage. So that highly politicized nature of it clearly impacted on collective bargaining. And on the other hand, you had this history of what was known and still known as the managerial prerogative. Now, these two protagonists, really, the way they engage each other on even on the work floor, on the workplace, at the workplace, was basically informed by that context of militancy on the part of the unions. It made for very adversarial, antagonistic exchanges. There was therefore, unsurprisingly, a combative nature of the engagement, which really had an impact on how then parties engaged. So we still live with that legacy even today, because many of the union and some of the union leaders have simply inherited that culture of being combative, and sadly, it has to be said, sometimes even violent. Therefore, we have our state of collective bargaining happening under that kind of a climate, which therefore leading to the next slide, where we talk about the level of trust. I mean, for any negotiations to happen, when the level of trust is not there, it makes for very, very, very difficult engagement. I know in this webinar, some of the people from Transnet in the negotiations are here. Yesterday, even in other sessions of our negotiations, I mean, I lost count of the number of times union leaders would say, we don't trust you. We can't trust what you're putting in front of us. So the level of trust is at an all-time low, which therefore makes it very, very difficult for parties to really listen to one another, because with that kind of mistrust, it makes very, very difficult. I mean, we have there a few examples of some of the statements and utterances which impact and indicate just how low the levels of trust are. I mean, in the public service, it's very instructive that at some point, Minister Mthimkulu accused one of the big trade unions there, the PSA, of undermining wage talks, while on the other hand, there's calls for him to step down from COSATU and Vavi, saying he's humiliating the public service unions. Even in our own sector, one of the two unions, Untu, says they have grave mistrust after Transnet made various announcements which unions saw as attempts at privatization. So in the midst of all of this, the levels of trust are very, very, very low, yet we have to engage in collective bargaining. Which therefore takes me to the next slide, where essentially we say all of this clearly has an impact because if you look at how collective bargaining has been happening over the years, certainly during the democratic era, you have a situation where I'm basically saying the cost to the economy is incalculable, because the outcomes of collective bargaining really are meant to drive the process towards what Vanessa was saying when she spoke about the growth of the economy, economic development. Now, when we have this level of mistrust between the protagonists in this field, it really happens at a huge cost to the economy. I mean, if you look at the industrial action report by the Department of Labor, the latest that I've seen is one for 2018, where it talks about more than 1 million working days that were lost due to 165 industrial disputes. Now, for a developing economy like ours, really, this is horrendous. Instead of us building and developing our economy, this kind of mistrust that characterize the negotiations precisely lead to this kind of things, because once those levels of trust impact on outcomes, and then there's disputes, and then there's power play, there's strike action, then it simply goes without saying that as a country, we simply cannot afford this kind of engagement. And then the loss, by what the report of the Department of Labor says, I mean, that's an estimate of that loss of 266 million. One can only imagine what that does to aggregate demand, because ultimately these wage earners have to spend income, but now when they've lost so much, the loss to the economy, the aggregate demand, how the loss of production as well. If we go to the next slide, I talk about other costs to the economy, not only the estimated costs. There's lost production as well. In fact, there's harm to the investor confidence. So we pay a huge price for this kind of scenario. There's also something that's not spoken about quite often, about the strike-related dismissals. I mean, I've read quite a number of labor court judgments where dismissed employees through their unions challenge their dismissal related to misconduct during strikes. I mean, in an atmosphere of this joblessness, somebody who loses their job through strike, it's highly unlikely they will find a job again. So when you factor all of that moving forward, somebody without a job having been dismissed with very, very slim chances of ever getting employed again. So the cost is really, when you work out those kinds of costs moving forward, such damage to the economy in terms of even the loss of lives, because some of the strikes unfortunately even lead to loss of lives. So you can't really put any price to that kind of damage. But I don't want to sound too gloomy. Yes, it certainly doesn't look good at all. But when you look at how this was supposed to pan out, and if you move to the next slide, I do indicate there that when you go back to the Labor Relations Act and the Basic Conditions of Employment Act, Basically, what I call 4 legs there about advancing economic development, social justice, labor peace, and the democratization of the workplace. This really was the way our legislator had foreseen to make provision that when the economy grows, when there's social justice, when there's labor peace, and indeed when there's democracy at the workplace, that's how this whole scenario should have played itself out. But unfortunately, it did not. And if we do find time, we will maybe deal a bit about how this was supposed to work out and try to chart a way as we move forward of how we are supposed to carry on with developing this economy and for the benefit of everyone. Ultimately, the Labor Relations Act, I would want to submit, did give a framework for how all of this should pan out. And therefore, we do have the architecture, and we indeed have the wherewithal, if we apply it correctly, as maybe even some of the inputs will show, that ideally we want to move to a situation where it was foreseen there should be economic development, there should be social justice, there should be labor peace and democracy at the workplace. Once we tie all of those, especially those 4 legs, I think we do have the architecture, as it were, to drive the process so that our wage negotiations, our collective bargaining, ultimately fulfills those outcomes that we had all wanted. I think I will pause there for now, Vanessa.
Thanks so much, Mthimkulu. Much appreciated your initial insights there and kicking off our discussions in that way. As I mentioned, we will be obviously engaging further with each of the speakers as we move through, but for now, I'd like to introduce our second speaker for the day, who is William Thomson. So William is a practicing attorney and a commercial and civil mediator who is accredited both by Conflict Dynamics and the Centre for Effective Dispute Resolution in the UK. He's a former director of the Independent Mediation Service of South Africa, known as IMSA. Some of you may recall that organization, and is also currently a senior CCMA commissioner and a panelist for various public and private sector bargaining councils and accredited private dispute resolution agencies. William teaches courses on negotiation, mediation, labor dispute resolution at a number of South African universities currently, and has also facilitated training and other processes and continues to do so for the International Labour Organization. Lastly, he's an accredited coach, both through the UCT Graduate School of Business as well as internationally, and is also a research associate in the law faculty at the University of Cape Town. So, William, welcome. Thank you for being here, and I'll turn over to you for some of your thoughts at this point.
Unmute myself. Thank you very much, Vanessa, for that introduction, and also Mthimkulu for that first bit as well. What I've got behind me, just on the flip chart here, is a picture of Section 1 of the Labour Relations Act, and its 4 pillars that Mthimkulu has spoken about, the economic development, social justice, labor peace, and democratization of the workplace. And I've had the privilege of being involved in a collaborative memorandum of understanding between the CCMA and universities in South Africa, teaching a course on labor dispute resolution practice. And interestingly, one of the assignments that we give to people on those courses is to look at the objectives under the purpose, to what do we understand by those particular pillars, and what about the interrelationship between them. And what I want to do just in the short while this morning is just to talk about particularly the leg on, just over here, on labor peace, and having a look at that. And Mthimkulu has pointed out those 4. And if I kick off just with the Labour Relations Act and just drop down to Section 1D, within the purpose there is to promote orderly collective bargaining. That's the first part that comes out, and it talks about it at a sectoral level. But then the last 2 points under D say that employee participation in decision-making in the workplace and the effective resolution of labor disputes. And back in 2011, I was working with a few other folks facilitating a process in Gallagher Estate, where the CCMA had a 15-year think tank to look back on really the first 15 years of the CCMA since its inception in 1996. And the social partners were there, government, business, and labor. And the main outcomes or the main learnings that were reflected on by the partners who were there was that labor relations had deteriorated in South Africa, talking about trust and respect and all the areas that really brought it down, that negotiation styles and approaches had become very, very adversarial and very combative. And coming back to the pillar on labor peace was that the CCMA was the busiest dispute resolution organization in the world, doing very well with conciliation and arbitration and dispute resolution. But the CCMA, bargaining councils, and other accredited agencies, there was a big emphasis on having a look at dispute prevention, capacity building, relationship building, and dispute prevention there. Craig, I wonder if we could just pop up the very first slide over there. That slide there, in fact, I could hold up as well, is The Economist, from October the 20th back in 2012. That picture was taken by photojournalist Greg Marinovich at Marikana. And what that illustrated was, I think it was just a very dramatic photograph. This particular hard copy and also the electronic versions went completely viral, just saying, and the question on the front here was, "Cry the beloved country, South Africa's sad decline." And that was followed up by other articles. I've got the Financial Mail, also from February the following year, 2013, Labour Turmoil, What's Wrong with South Africa's Industrial Relations. And if we move on just from that, in 2014, NEDLAC hosted, thank you, Craig, hosted a summit. I can see Alistair Smith, who's sitting in that photograph. I've just seen that he's part of our group as well. I had the privilege of working with Alistair as a fellow director at IMSA. Hello, Alistair. And next to, in that photograph there, we've got President Ramaphosa, who was deputy president at that stage, and looking into the state of collective bargaining in South Africa. On the other side of Alistair, who was director of NEDLAC at that stage, is former minister of what was then Department of Labour, now Department of Employment and Labour with Minister Thulas Mthimkulu, but the former minister Mildred Oliphant there. And this was a summit where the social partners were called together to have a look at the state of collective bargaining in the country. And one of the outcomes from the task teams at that summit was to present or to prepare, what I'm just holding up is the Code of Good Practice on collective bargaining and industrial action. And this was to really equip parties with the guidelines and the tools to be able to perhaps engage in collective bargaining in perhaps a more collaborative, more co-determined, more co-creative way. Craig, I wonder if we can just pop up the, thank you very much. So just in terms of the Code of Good Practice, I know one of our poll questions was just how many people are familiar with the code, how many people have used the code, and in the code, and in fact, right on the front here, it was actually signed into, it was gazetted in December 2018 by Minister Mildred Oliphant. And the code sets out, it's a code of good practice looking at collective bargaining, workplace democracy, it looks at industrial action and picketing. And the code, the purpose of the code is really to look at strengthening and promoting orderly collective bargaining by promoting the trust, the mutual understanding, and the constructive engagement, which speaks back to Section 1D in our very enabling legislation in the Labour Relations Act, and also the maximum involvement of workers and worker representatives in those negotiations. Craig, I wonder if we can just pop up the next slide. And so what we've just summarized just in those few points there is in the first part, part B, which deals with collective bargaining. There's a preamble, part A, which looks at putting into context and the purpose of this whole code of good practice. And then there's various parts there. Part B looks at collective bargaining. Part C looks at workplace democracy and dialogue. Part D looks at industrial action, strikes and lockouts. And Part E looks specifically at picketing. What I just wanted to home in very, very briefly, just in the last few minutes, just before I pass on to Clive, is just to say those are the key categories, looking at, in the code, the principles of good faith bargaining, looking at, what we look at in South Africa is we've drawn very heavily on best practice elsewhere, in the development of the Labour Relations Act, the International Labour Organization conventions and recommendations playing a very key role here in looking at good faith bargaining, and also within the context of decent work as well. Then we look at the development and support for negotiators, and that's all put into the Code of Good Practice. And we'll perhaps during question and answer time look a little bit more at the specifics around that as well. Then it goes in and it sets out very well how to prepare for negotiations, the different stages before the negotiations, even speaks about before parties even perhaps seek mandates from their respective constituencies, right through into the preparation, and then it even details out the actual opening of negotiations as well, and having a look at all those steps there as well. And then if we move from that to just the next one, it puts a premise on the use of facilitators, where parties could actually elect either one or two facilitators. And as we're having talks right at the moment, is the public sector negotiations have also elected to bring facilitators in to facilitate the process there as well. And it's going to be very interesting to see the role the facilitators have played there. And then one of the other points that comes through very strongly there is the disclosure of information, and that one can have meaningful negotiations when information that is important to those discussions is disclosed there. And then the last thing that I just wanted to say before I pass on to Clive now is just there's also within the Code of Good Practice, I'm just going to hold it up very briefly. It's called Annexure A over here. And there's actually a good faith declaration that parties can enter into right at the outset, where they choose the Code of Good Practice as being a guide for actually entering into collective bargaining and using that there as well. Vanessa, I think at this stage I'd like to end on that note. And I'd like to then hand over, and I can see that I've stayed within my 10 minutes. If I could hand over now to Clive, thanks very much.
Thanks so much, William. Very appreciate your preliminary comments in this way, and of course, having introduced the Code of Good Practice into our discussions for today, which is really important. Right, so let's move on then to our third speaker for the day. And I'd like to welcome Clive Thompson, apologies, to our panel. And thank you very much as well for being here today, Clive, with us. Clive is a director of the independent workplace consultancy known as CoSolve in Australia. He currently resides in Australia. He's also a research associate at the Institute of Development and Labour Law at the University of Cape Town, of which he was actually the founder director back in the 80s when it was known as the Labour Law Unit. Clive's also a former partner at attorneys Cheadle, Thomson and Haysom, and I think a number of you may know him in that context, and is also a former senior commissioner at the CCMA. So Clive, welcome and thank you.
Thanks very much, Vanessa, and nice to speak to so many people from afar. I must have a peculiar sense of deja vu as I just listened to the themes that Mthimkulu and William have been raising here. And somewhat sadly, the themes are very similar to what was being discussed in the 1980s and the early 90s, where the general analysis was, look, conditions are tough in society, we haven't got a great system, and therefore, but we are engaged with a great deal of collective bargaining. We've got to make the best fist that we can, hopefully not in too violent a fashion, And therefore, what can the parties do just to do the best they can out of the next deal? And so, and here we are, post-apartheid South Africa, 20 years later. And I would endorse what Mthimkulu said earlier on, that the architecture for the Labour Relations Act, 4 pillars and institutions is pretty good, but it hasn't delivered. And therefore, in 2021, as the parties face bargaining yet again, or the current round of bargaining, they are still in the situation where things are tough. What can we do in the meantime? And so I think as we get going in our discussion, as our discussion deepens, I think it's a mix of looking over the horizon, because we haven't reached the promised land in terms of labor relations. We still need to keep looking over the horizon of what needs to be done and the development points to try to get there. But in the meantime, 2021 is upon us, and what should we do in the meantime? And I think that's where, quite a clear focus on, as William has raised, the code of collective bargaining. Parties need to facilitate on some of the tricks of the trade there and some of the big factors, plenty of disclosure of information, use of facilitators, trying to make the bargaining as productive as possible. That needs to be done. And then there are also, even now, some radical solutions. And I know from our earlier discussion that I suspect that Mthimkulu is going to raise this a little later. And one of those radical solutions is to say, look, let's be honest. We haven't got it right with our collective bargaining. It's not delivering the goods. And we should go to voluntary interest arbitration and simply make the process rational that way without disruption to the economy. It's not giving up the right to strike, because it would be done voluntarily. And we simply need to do this. And I'll look with interest to see what Mthimkulu might want to be raising about this a little later. But in the meantime, I'll be going a little bit over the horizon and saying, again, picking up the themes of trust and respect here, also from the code and from the previous speakers, and just noting that because it's a cultural dynamic, the bargaining process, and because goods and services are not produced in bargaining, they're only distributed there, I think it's also incumbent on the parties always to look at the relationship resets. And if they have that luxury, to have a look at the a situation of, sorry, just bear one moment. Yeah. And to have a look at a situation where you try to encourage the parties, as they're about to go into this year's bargaining, to look at that big picture. What is the state of the business or the public sector? What are the services one is trying to deliver there? What are the constraints? Where are we falling short in our own relationships and so on? And so that, because bargaining is only a feature, the really big deal always is productivity in the workplace, whether it's public sector or private sector. And that is the main game, and that's the main game which parties should be concentrating on. And that raises another theme, which I know my colleagues will also be coming on to a little later on in the program again, and that is going back to the original DNA of the Labour Relations Act. So yes, there are schemes there for collective bargaining and the right to strike, but there are also schemes there for growing the economy through innovative engagement through institutions such as workplace forums, and that's one of the areas where we've let the ball slip a little. So these are that's the tension between the immediate stuff we need to deal with and then the larger stuff over the horizon. And I do think that the parties who can have the luxury, if they can, of before they're cracking into this year's bargaining, bringing the parties together for a much broader conversation and dialogue, that would be handy. And if you can't do it this year, well, perhaps you can do it in another year going ahead. Again, Mthimkulu said, look, things are tough, but we don't want it to be all doom and gloom. And William too has raised some of those beacons of workplaces in the South African economy where things are going well. And I always think it's really ought to be incumbent on each major sector and amongst the large organizations to say, yes, can we pick a workplace and we really want to turn things around? And we want to make it a great place in which to work. Bargaining is part of that, but ongoing relationships day to day are part of that, consultations, operational items and all the rest and so on. And I think that that's an area where where South Africans could do well to put a fresh focus. We know that there's been plenty of activities like this over the decades, and the difficulty has always been in sustainability. I know too that the CCMA over the years has picked up an emphasis here on occasion, but I think also needs to run with it sustainably. I can just mention, coming from an Australian context, that the equivalent of the CCMA in Australia is the Fair Work Commission. And about 8 years ago, they put together a dedicated division of that organization, and it's called the Cooperative Workplace Initiative or role. And what they do is to invite the parties well in advance of any collective bargaining. What is the challenge that you've got lying ahead of you over the next couple of years? And you can draw on our resources to help you facilitate those conversations. Again, this is happening a lot in the side stream in South Africa, but I think it would also be good if our legislative body, our formal judicial body, quasi-judicial body in this area, were to pick this up as a very developed theme and to run with it into the future. So these are just some introductory thoughts, and I'd be interested to see how my colleagues and indeed through your questions, how we deal with the tension between, well, what do we have to do in 2021? Here's the current situation and how best do we manage it given our respective situations. And beyond that, how do we try and invest in for the future? We've already had 25 years since the LRA came into being, unrealized promises. How do we try and recapture the original vision? Thanks very much.
Thanks so much, Clive, for your input and your initial or preliminary comments there. And I trust that we're going to develop a lot of that thinking further as we go through some question and answer and so forth. But before we do that, having heard the introductory thoughts from the three speakers, we thought what we would do is just throw a couple of questions out there to you as listeners and participants in the background of this webinar. And so I'd like to ask our administrator, Craig, if he would put up a quick poll. There we go. You should now have on your screen two initial questions that we would like to invite you to respond quickly to. The first one relating to the level of awareness of the Code of Good Practice for collective bargaining, which William specifically referred to. So if you would like to just quickly read through the options there and record your response. And then the second question also around the Code of Good Practice, but specifically to what extent it's been used. So let me give you a minute or so, everybody, to just record your responses, and we can see what the audience has to say about this. Craig, are the responses coming in?
Yes, they are. We're on 61% of people have completed. I'll give them
excellent. Let's give it another short few seconds.
Sure.
Okay.
It says hosts and panelists cannot vote.
Yes.
I thought voting was a constitutional right.
Not in our webinar, Mthimkulu, so sorry. Right, so having heard from our participants, what do we have here? So in terms of awareness of the Code of Good Practice for collective bargaining, we've got 49% of the respondents, 20 people specifically, who have said that they do indeed know about the code and are familiar with its contents. I think that is encouraging as a start. We have 34% who said they've heard about the code, but don't really know what it's about or what it provides for. And then 17% who say they've never heard of it before. Well, The good news about the response to question 3 is that after attendance at today's webinar, it'll be useful to have introduced that concept of the code and its value to the bargaining process. In terms of responses to use of the Code of Good Practice to date, who has used it? I see that the greater number have replied, 56% have replied that they have not in fact used it yet, but an encouraging number of 44% have in fact started to engage with and use the code. So perhaps William, in due course, just now when we invite you to have some more input into the session, you might want to just comment about what we've seen there. But we do have another poll for you, just very, very quickly, another question that we'd like to pose. So Craig, would you like to put that up quickly? So question is as follows: for those who are participating here today, who will be engaged in collective bargaining this year, would you describe the likely mode of your upcoming bargaining as traditional or relatively adversarial? Or would you describe it as more cooperative or mutual gains inclined? Apologies. So take a few seconds just to record your response to that, if you will. Right, we're getting responses in, Craig?
Yeah, we're on 40% almost. So 22 people.
Okay.
Let it get up to about 60% or so.
Right. I think our audience perhaps wasn't expecting to have to participate so much. Thank you, everyone, for recording your thoughts as well to these questions.
Okay, I think it's stalled there, so I'll share the results now.
Excellent, thanks. Okay, so of those who did respond, we have the majority, I guess not surprisingly, reflecting that it will be focused on a traditional or the relatively adversarial type approach. And then 12 people, or 44% of those who did respond, and encouragingly so, indicating that the focus will be more cooperative or based more on the mutual gains approach. So thank you very much, everyone, for participating in the poll, and I'm sure that those results will feature in our speakers' further comments. What I'd like to do, though, is just at this point pose a couple of additional questions to our speakers and just invite them to open up a little bit more around their thinking on certain issues. And I'd like to start again with Mthimkulu, if I may. And Mthimkulu, I know that you, in your opening remarks, you briefly referred to one of the pillars of the LRA being the democratization of the workplace. And I know from having spoken to you previously that this is an area that you're passionate about. And I was wondering if you would perhaps just like to speak to us a bit about how you see this happening in practice at this point in time in our country.
Just unmute. Thank you. Yes, Vanessa. This issue of democratizing the workplace, I do strongly feel that had we really paid the attention that we were supposed to have paid in that, we wouldn't be here today. Because the way I see it, in fact, the LRA is very, very clear in the way it was really promulgated to make a clear distinction between matters for collective bargaining, typically your wage increases and benefits, like your medical aids and other benefits, on the one hand, and matters for consultation,
Thanks.
Could I just come in there?
Yes, absolutely.
Yeah, just with an observation. So we go back to the 1990s. It was an era where most of the larger unions were affiliated to COSATU, and the notion of majoritarianism, ruled very strongly there. And as the more powerful party, the COSATU unions were wanting that to be part of the formula. I think in 2020 and beyond, all the unions and all the parties need to be a little bit more humble. No one has got a monopoly anymore in the sense that they used to. And by that token too, the notion of majority unions, controlling the formation of workplace forums or not, has also changed. Now, I appreciate that we're dealing with a topic where, not as if people in 2021 can suddenly set up workplace forums. So this part of the discussion is not going to aid you in your current negotiations, but it is part of the longer and the bigger thinking. And I do think that, first of all, the entire institution of workplace forums, where the discussions over creating wealth, for, as Mthimkulu said, it's distributed later in the collective bargaining. I think that whole debate needs to be revisited, and we probably need to look at the trigger mechanisms as well to make those workplace forums more inclusive and more easy to establish.
Thanks very much, Clive. There are a number of questions that are coming through in our chat function. So please, I just want to remind everyone that there will, of course, be opportunity for those to be, or as many as possible, to be posed to our panelists. So please do keep your questions and your comments coming through the chat function. They are appreciated. Perhaps if I could just bring William in again here. And William, you spoke to the existence and the purpose and the value of the Code of Good Practice on collective bargaining. So maybe you have some thoughts in connection with the poll results that came through. But aside from that, or in addition to that, I remember you telling me a while back that you had been facilitating a collective bargaining process where you were using the Code of Good Practice with the commitment of the parties, and that this was prior to the code having even been gazetted. So perhaps you could tell us just a little bit about that process and specifically maybe what caused the parties to commit to that process at that time, at that early stage of things.
Thanks, Vanessa. Yes, that was actually around November, December 2018. And in fact, the Code of Good Practice was signed into being gazetted it was actually the 12th of December 2018. And a colleague of mine, Kaiser Tubedi, and myself, both senior commissioners of the CCMA, we'd been asked to go in to facilitate wage negotiations between a very, very large employer in Gauteng with 5 trade unions and fairly diverse trade unions as well, right across the spectrum of that particular employer. And Kaiser and I, we introduced to them this draft that was going to be imminently signed into being gazetted as the Code of Good Practice. And none of the parties were actually familiar with it at that stage. And what they decided, they looked at it, they went off on their separate caucuses, probably all 6 of them, because there were 5 unions in the employer. And they decided they'd like to adopt the Code of Good Practice as being, even without it being gazetted and it's still being in draft form. And what Kaz and I put to the unions as well was whether they wanted to work separately in the negotiations or whether they wanted to work together. And again, after a little while, they decided they wanted to work, and they called themselves a coalition of trade unions with this employer. And they were very, very diverse unions. We put together we cobbled together. We didn't even use the annexure sheet. We actually put our own sort of sheet together around how the coalition of trade unions would actually engage with the employer. And what we found, because those negotiations went over this November, December, January into the February, and there were a number of items on the agenda to be negotiated, was that at times when the negotiations got stuck, what was very helpful was the parties were able to go back to what they had actually committed themselves to at the beginning, and based on the principles of the code. And it was that commitment to the process that enabled the negotiations to continue, even at some very difficult times as well. So that was that very, very first experience of facilitating in terms of the code.
Clive?
Yes, I'm going to interrupt the next contributor as well. I think this might be a handy time just to pick up, William, one of the questions I see from Johan Skeepers, and if I can read it out and take over your function slightly just for the moment, Vanessa, but I just think it fits very well with what William just been chatting about. So Johan says, do you anticipate that detailed preparation for negotiation will lower the adversarial nature of SA collective bargaining and decrease the incidence of destructive conflict manifestation during the collective bargaining process, industrial action characterized by violence? So, and being from afar, I defer to my local colleagues here. Clearly, the intent of the code is to try and inject more rationality into the collective bargaining process, whether it's a more traditional one or going in the more cooperative direction. So that is its intent. And so if I can chuck the question back to you, William, to what extent would you say that if the local parties in a relatively rough neighborhood of bargaining in South Africa 2021 were to say, we're going to very consciously, we've agreed at least this much, we're going to pay close attention to the code and adopt as many of its features as possible, what do you think should be the prospects of improvement compared to what would otherwise be the case?
Clive, thank you very much for that question. I'm going to start off that question by just recently, I'm just having a look at the actual source of that, but a few years ago, Rolf Meyer, one of the chief negotiators in the CODESA negotiations with President Ramaphosa being the other chief negotiator. It was called South Africa's Negotiation Revolution and Mandela's Legacy. And a few years ago, he was interviewed at the program on negotiation at Harvard as to what would he take away from those CODESA negotiations as being valuable learnings that he could contribute back. And he came out with two key things. Often as mediators and as when we train on negotiation skills, we often talk about, we call it the 3 Ps, the people who are in the process, the people, and then the process and the problem. And without using those terms, Rolf Meyer was saying that 2 key things that he took out of those CODESA talks was the trust between himself and his opponent, chief negotiator, or whether it's 2 teams. And the second thing he spoke about was the process itself. So coming back to your, and what he spoke about was at a time when the negotiations did come unstuck at a particular point, they were able to go back to, there was a very trusting relationship between the 2 negotiating teams, and particularly the 2 chief negotiators. And he spoke about being able to go back to the process. And he put a huge emphasis on the process. And if I bring it back to your question and also to the South African situation at the moment, where Mthimkulu and yourself and myself, you know, have looked at the incredible, the low trust between the parties. And what I'm thinking in South Africa is it's not about the problems that we have. The problems are there. It's a case of how we address the problems. Do we do it in a positional, adversarial way, or do we do it in a mutual gain, interest, needs-based kind of way? And I think out of those 3 there is that if South Africa's right down to saying that there isn't the trust, so it's not the P for the people, and the way we're engaging in the problem might not always be as healthy and functional and as needs-based, interest-based. That almost leaves us with one thing, which is the process. And what I like so much about the code, and having facilitated a number of processes with colleagues using the code, is how if the parties up front can commit to using the code and following its process, what I'm seeing more and more is the facilitator or facilitators in that process play a role of bringing in a mix of their negotiation and mediation skills, but also coaching skills and very strong problem solving skills. And what I've experienced too is that those facilitators need to sometimes be quite robust with the parties as well, and quite firm and set some boundaries. In one of the processes that I was in there, I didn't think I'd be invited back the next day. Kaysa and I were negotiating, and we needed to be quite firm and set some quite clear boundaries because the process was becoming very, very difficult. And well, the next day we were both welcomed back, and I think they appreciated that while we were firm on those issues, is it that it enabled it to go further. So Clive, coming back to that, is I think that in the use of it, if parties commit to the process, and have a strong facilitator or facilitators in the process. This term of being a conflict coach is that the facilitator of the process is playing a very strong role on coaching through that conflict and being a very strong problem solver. So even if it's reduced us just down to having a process and committing to the process.
Thanks very much, William, and for picking up on that question, Clive. There are a couple of questions that, 2 in fact, that I think I'd like to dip into here that have been posted by participants. And perhaps, Mthimkulu, maybe you would like to comment on these, given the fact that you are, as you've told us, currently completely mired in bargaining. You are busy with it as we speak. You are living and breathing it at this point in time through the current process that you are engaging in. So we have a comment/question, if I can just find it, from Johan, who says, it has been mentioned that trade union negotiators often accuse management of distrust, but surely such sweeping statements should be substantiated by facts. Have the employer negotiators called on the trade union to substantiate such allegations? That's the question posed, but I want to just top it up with a comment that has been made by someone else in our audience, which I think ties in with that, but comes from another perspective. And we have Tokozani, who says, But most of the companies are still being very selfish. Most of them in these current collective bargaining processes hide around the issue of COVID-19, whereas they've made millions of rands in profit before this pandemic. To us trade unions, we are seeing this as part of behavior that leads to mistrust. So I just thought these were two interesting comments / questions that have come through. And I don't know if you've got any comments, either Mthimkulu or any of the other panelists, in response to these observations around the trust issue.
Yes, Vanessa, let me pitch in there. I saw that question about substantiating these accusations of trust. To answer directly, the negotiators from the other side, from management, have not challenged. But I suppose when you think about it, where would it get the parties? But the levels of mistrust are very, very clear to see. I mean, you see, just as a simple example, maybe to touch on another question that I saw in the chat about how do you unrecognize unions who have not met the recognition agreement criteria. So the levels of trust, and also when you talk about recognition agreement, for instance, we had early this year a workshop on the recognition agreement. You would ordinarily think a recognition agreement has been signed by the parties, but in my experience, it became very, very clear that there is a need to actually do a workshop so that the recognition agreement becomes your rules of engagement, as it were. So if there is not a common understanding of the very, very document, you can imagine the kind of things that would happen. Therefore, to sustain the levels of trust, to deal with another question that I saw, is that these kinds of engagements with facilitation by skilled mediators like William Thomson there, who I must say I have used before, it helps the process because building trust and building relations, the workplace forums, yes, I've been singing that tune of having them to give you that opportunity. But you need other practical steps where you do your relationship by objectives, you do your workshop, or where you train on collective bargaining, or you train on the recognition agreement itself. It's a process that you must undertake consciously, both parties. And it always helps to have an outside person with a bird's eye view, as it were, to assist in building those levels of trust. So there's a lot that can be done I mean, in South Africa, we have a rich culture of resolving things through talking. The very, very new dispensation was arrived at through talking. It always pains me that in the labor front, we don't really use that opportunity, those skills that are available. There were people who were in the old IMSA and other institutions that really can help us. Also, previous leaders of trade unions. So there is a rich vein of material that we can really tap into to build all of this culture of trust. Because once we have the area of the issue of trust, I do strongly believe we will get far. Maybe just finally on the issue of companies hiding profits, I would invite, I mean, there's just, when you Google somebody called Dan Price, there's a CEO of a company who is revolutionizing the way CEOs should be dealing with their employees. I mean, in order to up the salaries of his staff, he cut his own and moved around the way the distribution of the wealth of the company, starting with himself and with others. And you can imagine how that built the trust, such that when the COVID hit last year, he did this thing 5 years ago. His own people were so invested in his company that they came forward to say, we are more than happy to take a salary cut. I mean, it's unheard of employees who come forward and say, to meet the difficult conditions we're in, because of the trust you have shown us, we want to take a salary cut. And indeed, they did. Some of them up to 50%. And when the company also started to turn things around, he paid them back and said, I want to pay you back the monies you forfeited during the early years of the COVID. So that's the kind of trust relationship where we can all work towards. Thanks.
Thanks so much, Mthimkulu. I'm just thinking, in discussions around the trust issue, there is often a thought around a formal relationship building process taking place, perhaps before even a facilitated negotiation process were to commence. And maybe, William, I know this is an area of passion for you and an area that you have a lot of experience in. Is there anything you'd like to add into the mix around particularly trust building and the relationship by objectives type process?
Thanks, Vanessa. Part of our group today is also one of the directors of Conflict Dynamics, Felicity Stedman, and I know that she was involved in the late 80s going into the early 90s with a very big automotive and automobile company, together with a very strong trade union there too. And I think what they were looking at that stage too was it was a very adversarial relationship. And what they discovered was that if they continued on that path, that company was actually talking about disinvesting from South Africa, and it was going to have a very strong impact on the economy, on jobs, on inequality, poverty, and everything else. And they, through a relationship building process, looked at their interdependence and looked at the various alternatives. And that particular automobile company now in 2020 is building a particular vehicle for the international market that is being built in 4 other countries. And South Africa boasts the highest quality and highest productivity of that particular motor vehicle in the whole world. And that is not the only organization in South Africa where organized labor, and it might not just be one union, it might be multiple unions together with employers, have found a way of realizing this interdependence and saying we don't have to like each other, we don't have to love each other, but if we can find a way of moving forward. And I've personally been involved with my colleagues in a number of relationship building processes where the parties have sat down and through independent facilitation have looked at the various alternatives and worked together. And a few years back, I was called in actually by the CCMA to facilitate a relationship building process. And during that process, the parties said we're about to go into our annual negotiations. They've always been fraught with a lot of conflict and ending up in disputes. And they said, we'd like to have negotiation skills training for all our chief negotiators, both from the unions and from the employer. And after that training, where we dealt with the Code of Good Practice, they then adopted the Code of Good Practice as well and said, we would like to use this during the negotiations too. So it talks right back to that whole link of, and also Clive's earlier question, is that but there are areas where there is trust between parties, but there is a huge deficit of trust in our labor market in negotiations. And if through adopting a process to follow in preparation and then being in the process, and that's where I think that the people at the NEDLAC summit and in the task teams said that maybe we're at a juncture in South Africa where instead of going to the courts and going to adjudication on all matters, can we talk, can we discuss, can we be collaborative and co-determined in this? And so that's again where possibly with the right facilitators in the process to try and, even with the lack of trust, to try and keep the parties to a process and at least be able to understand that interdependence and then also assist with those problem-solving skills. So yes, relationship building processes, there seems to have been an uptake in, can we get together? Can we look at what's working, what's not working? And how could we move forward in our workplace relationship?
Great, thank you. Yes, Clive, you want to come in there?
Yeah, I wonder if this might be an occasion, just because there are some, I think, steady themes coming through here from the panelists. And one of them is what Mthimkulu's been saying about we need to grow the pie, not so much haggle over splitting it. And then the emphasis then on trying to grow wealth through a different kind of engagement in the consultative stream, workplace forums, or some other non-statutory form of that, and so on. So I'd almost like to ask Mthimkulu here, as I say, because I know you'd raised it previously in the lead up to this webinar. What would the case be, and would there be any Labour political appetite for saying that over the next 3 years, it has to be voluntarily, so it'll have to be site by site and union by union agreeing with employers, to say we're going to focus on relationship rebuilding, a relationship reset. We're going to do these RBO and RBI type initiatives to try and get us going. And in the meantime, we're going to put the periodic wage adjustments up to voluntary interest arbitration. So guess what? In our sector or divisions, there are going to be no strikes because we're going to take the outcome of arbitration. We may lose some, we may win some, it may be a compromise, but at least at one level, it's a highly cerebral, rational process. And the country for the next 3 to 5 years is going to concentrate on engagement and on upskilling and on higher productivity, so that with a bit of luck in 5 years' time, we can have a good strike because there's something to share. So my question, I suppose, in Mthimkulu, so would you want to run with that proposition for a moment?
It's a very interesting proposition, Clive. Thank you. In fact, in 2019, I wrote on my Facebook page what some would call is an opinion piece precisely on that, because I was basically arguing that the economy cannot afford these kinds of disruptions and the costs associated with labor unrest. In fact, I also saw in that piece as well that when you see the actual settlements that then get reached, and I also made examples of a few cases where interest arbitration was done, there doesn't seem to be an appetite for interest arbitration. Well, going by the few of the people who commented on that Facebook post, that by no means is a scientific survey. I'm not saying that at all. But the knee-jerk reaction, especially from union leaders, is that no. We can't take away our power through striking, and nobody's suggesting that. And I think it's a very interesting proposition that you're making, Clive, because if we can have some kind of moratorium on power play, not only to build the relations, but also to make sure that there's really a more kind of equitable dispensation. Because when I read some of the earlier awards, I mean, one was by John Grogan. It looks to me unions would have to really improve on their presentation skills, because he says in that award, for instance, that the unions don't lead any evidence. They are just happy to interrogate and cross-examine the witnesses of the employer who came to justify why they put this. So I think there's a lot of what training and education maybe that would need to be done, so that when you present your argument now in interest arbitration, like you do in any other arbitration, you want to make a convincing case. So I would strongly support that proposition, that while we promote interest arbitration, obviously voluntary, and then in the meantime, to take away this adversarialism and this aggression and this fight associated with collective bargaining. That would really give the whole country a kind of a breathing space, a reset button, if you like, so that workers still get whatever is due to them through interest arbitration. And then in the meantime, we run a series of relationship building exercises to make sure that parties do really find each other in an atmosphere of less adversarial.
And if I can just chip in there, the idea is not merely that there's some moratorium, and obviously, as you said, could only be voluntary. That you can't strike, and you have to take potluck with an arbitration process and try and skill up for that. But as you're saying, during that period, not only should there be relationship building, but the relationship building is towards an end. The relationship building is for better engagement, for productivity on the work on the work floor. And in the meantime, there should be rewards flowing from that. So when the arbitrators need to arbitrate, there's something more to talk about. And it doesn't have to be everywhere. It could be in just the brave people in certain areas that you have to be politically courageous to do this. Could trial it a 2 or 3 year period and be very interesting to compare their results compared to those who stay with traditional. And who knows, it could be that William's earlier story of the butter manufacturer who's now world competitive, perhaps that could be replicated a bit more strongly across the South African economy.
Maybe I should start here at home, Clive, and try and win the parties within Transnet so that we can give that a chance, basically, which, who knows, it might serve as a kind of beacon to everyone else that this can be done. And starting with what we started earlier on now with the relationship building that we've done with the new management. I mean, I was very heartened when we had this workshop where the very top leadership, Portia Darby, the group CEO, everyone with their entire executive, union leaders in this workshop on the recognition agreement itself. So that for me, I've seen that as a positive start where we can then start building the relation moving forward. Hopefully, we will reap the rewards as time goes on.
Mm. Well, as we start moving towards having to think about closing our webinar, the one thing that we wanted to make sure we touched on amongst various thoughts that came through was as much practicality as possible. And Mthimkulu, I'm not sure if you happen to have seen another question that has come through, but it's directed, or it's posed to you. So I'm going to read it to you and see if you have any thoughts in response to this. I think it's quite an important question. Tokozania says, Comrade Mthimkulu, given the current collective bargaining process in Transnet, what could be your advice to us in Satawu and Transnet that will ensure that we finalize the process with both parties emerging victorious? And I guess the emphasis there would be on both parties emerging victorious. Any words of wisdom, Mthimkulu?
Yeah, I don't want to preempt anything now because I appointed a very experienced conciliator, Misha Gravuku, who was really trying to get to the heart of the issues. And I would want to leave it at that stage where he basically made a proposal, which he will then forward. But your leadership, both Satau and Undu and Transnet, were quite happy with my appointment of this very experienced former unionist as well. So I think I would rather leave it at that let's see what Misha Gravuku tries to come up with by way of what is sometimes called a conciliator's proposal, and then we will take it from there. And I'm speaking under tremendous constraints because I'm not mandated to speak on behalf of the parties, but I think it's also a constitutional principle to really be open and transparent, but without upsetting the apple cart, as it were.
I'm going to just feed into our discussion one more specific question from Johan that has actually just come in before, as I said just now, we start moving to some closing thoughts. So Johan's question that has just come in is the following. What are the panelists' viewpoints on a med-arb process where the mediator mediates the interest dispute up to the point of deadlock and an arbitrator then arbitrates the interest dispute? And he says, just a thought. Anyone, William, Clive, or Mthimkulu, like to respond to that?
I'll happy to kick off in the first instance. I think that, you know, we should be experimenting with different approaches, and med-arb is one of them. It is used in South Africa, not very extensively, but again, against a backdrop where we're not being terribly successful in the bargaining process and the bargaining consequences, then I think, again, under the heading of making the process more rational, more structured, yes, indeed, process matters, something like med-arb should be experimented with. A mediator can come in and try and close the gap. And if that doesn't close the gap, if the parties are brave enough to do so, then to hand it over to an arbitrator so to do it, provided other things are going in the other stream, which we'd mentioned earlier on.
Maybe, Vanessa, I can just add to that. And again, it was a process that Felicity Stedman was involved in quite a number of years ago. It might have even been in the IMSA days, or certainly where you have the ARB med process as well. And I do remember speaking in great detail and being very encouraged by the process where she had stepped in and actually arbitrated a dispute. The parties knew that there was a decision that had been made, but they didn't know what the decision was. And they then went into a mediation process, and the parties settled in that mediation process. Because they knew that if they didn't, they were going to have an adjudicated decision there too. And in my work with the CCMA and other, organizations as well, is how many times we have a CONARB process, mediation, arbitration, conciliation, arbitration, and very often the parties don't settle in that initial process in the conciliation or the mediation side of the process, but they get to the arbitration and they often settle at the arbitration. And I think a lot of what's happened is they've had some time to think and do reality testing about the strengths and weaknesses, and certainly as commissioners and as facilitators and mediators to give the parties an opportunity to see if they'd still like to collaboratively settle, and many, many times come out with a far better, more sustainable, stable settlement than might have been through an adjudicated process.
Mm. Great. Well, thank you. Thank you. I wish that we had much, much more time at our disposal to continue these discussions, but I will hint at an opportunity to do that at a later stage when I do the closing in a moment. Before I just do have some final thoughts coming through from my side, I would like to just give each of you as panelists, as they say in some of these TV shows, you've got 30 seconds, no more, to answer this question. So perhaps, Clive, I'll start with you. Same question to all of you. And the question is basically just that of practical advice. So really what I'd like to ask you is just, what do you believe is the most important thing that the parties who may be headed for negotiations now or currently involved in them in 2021, what is the one most important thing that or important piece of advice that you would give in 30 seconds or less? Clive?
Thank you. So counterintuitively, I'm going to look at this side of over the horizon. I'll leave it to my two colleagues to look at 2021, this side of the horizon. And I'd like to pick up on the question of my Israel partner, Tefera Tepolo, who's come through. And he said, well, the South Africans should have a look, the rest of SADC, and particularly Botswana, and how, if you look at what the example that he gives there in the script, that the parties there have taken more of a social partnership as social parties and partners going ahead. And I think my advice to the South Africans would be, look at other exemplars, look at Botswana, and get some inspiration there about how to create a local partnership.
Thanks, Clive. Thanks, William. Would you like to go next? You're muted, William. Just unmute yourself.
Sorry about that. I see my supervisor, Professor Debbie Collier, is with us today as well. And we've had discussions around, even with the most enabling legislation in the form of the Labour Relations Act and the Codes of Good Practice and CCMAs and bargaining councils and all the structures that we can have to enable, constructive dispute resolution. How come things are the way they are? And what do we need to change the labor laws, or is it the people's behaviors? And I believe we don't need to change the structures that are there, but it is the people behaviors. And I think I saw a question come up in the chat there a little bit earlier about capacitating negotiators on both sides of the table. And I'm just looking at the Code of Good Practice, and in item 8, it speaks about development and support for negotiators, and the training and the capacity building. And then a little bit further on, the use of facilitators where that might be useful too. So I'd say have a good look at the Code of Good Practice. There is so much value in the Code of Good Practice, and even with very low trust deficits, and even perhaps very adversarial problem solving, whatever there might be, there is the code does offer a mechanism and a tool to try and enable perhaps more collaborative discussions and conversations.
Thanks, William. Mthimkulu, your closing input?
Yes, thank you very much, Vanessa. My closing input really is to call on the parties to really practice and implement the art of listening. Let's just listen to one another. Listen not with the intention to reply, just listen. I like one of the points that Stephen Covey in his book on the 7 habits. Just strive to understand before you seek to be understood. So listening for me is the key. Why are we talking past each other? If we can just pause and listen to one another, maybe, just maybe, we can then find a way of moving forward. We will certainly not agree, but at least we will have listened with a mindset of trying to understand, and then we move forward with having listened. I think that will give us a way forward. Thanks.
Thank you so much, Mthimkulu. And of course, just in closing, I want to really thank our 3 guests profusely for their time, their valuable input and viewpoints, and the guidance that has been provided. Clearly, we can say there's no quick fix to this challenge that we have in the South African labour landscape around collective bargaining, but there is a lot of work to be done. But we just hope that a few of the things that have been mentioned today will be of value to you. And I want to mention that we are very much planning to have a 2nd edition of this webinar in due course. Obviously, watch the space. You'll see our communication about it, where we want to look further ahead at what can be done in the longer term to really revitalize, refresh, as Mthimkulu has referred to, the whole area of collective bargaining in our beautiful country. Just by way of a last mention, if you have had your interest piqued in any of the areas that Bill has mentioned that feature in the Code of Good Practice, for example, preparatory matters such as going through training in negotiation skills, and that would be either for union or for management representatives, or you have any interest in exploring the use of a facilitator for your wage negotiations, please be aware that Conflict Dynamics is able to meet your needs in that regard. And we would invite you to please have a look at our website and see how it is that we could assist you in that way. Or feel free to call us by phone, email us. We would love to engage with you and see if there is any assistance in the form of training or facilitation that we can offer to you. I just want to thank you for joining us today. Please continue to stay safe. And we wish you every success in your current or your upcoming bargaining processes. And thank you for your attendance today. Goodbye, everyone.